Good morning. Well, rape is something which is horrible, and any rapist must face the consequences. But when sexual assault is used as a means to wreak vengeance or is unsustainable, then that's equally bad. And sometimes I wonder that the Liberal Party of Canada and the Liberal leadership is bidding goodbye to the very concepts of liberalism, because liberalism believes that everybody must be given a chance to prove himself or herself innocent. And once the person has been declared to be innocent or guilty, as the case may be, by the due process of law, the most important is due process of law, and that is that every human being has a right to defend himself or herself. Now the government has introduced a new bill called C-51. This bill has passed the second reading, just now passed the second reading, and has been sent to the Committee of Justice and Human Rights. This bill is a catastrophic attack on the rights of the accused. Every human being is an accused till is proved guilty. An accused does not mean guilty. And this bill is going to be of great interest to the feminist, radical feminists, but would ruin the lives of many young people who may be unjustly accused of sexual assault. This bill is going to prohibit the introduction of sexually explicit text or emails in a court of law until and unless a judge has proved them to be admissible, and he may not. Now, what happened was that a CBC host, Gomeshi, was accused of sexual assault, and he brought out the emails from the girls who were allegedly his victim, and the girls were always talking about his beauty, his hands, and they were sexually explicit. They wanted relationship with him. And based on those proofs of relationship, a proof of acceptance of relationship, Gomeshi was let go. He was freed. And now the government of Canada says, no, if you have been charged, you must be guilty. This is in fact Sharia. Two people say that the girl has committed zina, adultery, and she must be stoned to death. And if she shouts that somebody has raped her, she must show 4 eyewitnesses who would say that she has been raped. And from where do you get the eyewitnesses to a rape? You know, there is a mistaken notion that the justice system is skewed against women. It may not be. It may be. There's something different. But it's unfortunately true that this is happening. Remember Lucy de Cottre's email when he said, I love your hands. And then she accused Gomeshi of sexual assault. A consensual sexual act is not sexual assault. Now, the new bill is in fact a scandal and is a reversal of the due process of law. The traditional understanding of the due process of law is that the burden of proof of guilt is on the Crown. And the columnists have said that this is an attack on the ability of the defense to make full answer and defend, and this is unprecedented. Now imagine you have a proof and you cannot have a proof. Now if this will pause, what will happen? The defense will be restricted in the evidence that they can lead. They cannot present the case history. And as a matter of fact, they risk that a complainant will see who participates in the closed hearing, knows what the fact is, and he's tipped off, and he can easily say, no. So you have got to show the email or that proof to the prosecution. You show it to the prosecution, and when the prosecutor says and appears in the court as a witness, she can easily be tutored to say no and get away with it. Now, as a matter of fact, the head of the Ontario Criminal Lawyers Association, Anthony Musclis, talked to me. And he said, very clearly said, this law is using the power of the state to help the prosecution prosecute the accused at the accused expense. Now, isn't that a travesty of justice? Why do it? You might ask, as a friend of mine has just commented, what was the need of such a bill? The need is, again, politically oriented. To win over the women and posing as a protector of women, this bill has been brought. The need is the same. What was the need to pay Omar Khadr 10.5 million? And that too income tax free. So that the American woman doesn't get her due. The American woman whose husband was killed and the other whose husband was blinded. Anyway, that's a different matter. But then there's a need to create a vote bank. If 71% Canadians have opposed payment to Khadr, there must be a way to win back some of those 71%. And what better way than 50% of the population, without thinking, would say, wow, that's a great thing. This is protecting women. This is protecting the integrity and honesty and honor of women. In fact, the whole bill is a Machiavellian and mischievous device to prosecute people and to declare accused to be guilty without due process of law. The bill would stop the defense from introducing any sexual nature communication as evidence. And then, when the evidence, the real evidence cannot be produced, then it's a question of he said, she said. And that, in fact, when you are showing the evidence to the prosecution before presenting in the court, it's like playing cards and you show the cards to your opponent. As a matter of fact, the defense attorney under this bill will become team B of the prosecution, an unwilling player, an unwilling partner for the Crown team. What a travesty of justice. And then we are honestly crying from the top of our houses that we believe in the due process of law. It is so misguided that it tantamounts to a repeal of the basic concept of judicial system. The judicial system is a man is presumed to be innocent till proved guilty. And here, the presumption of innocence has been taken away because it weakens the defense, and weakened to the extent that you cannot defend yourself. Canadians have a charter right to defend themselves against self-incrimination. And nobody is accused, is supposed to speak to the police or at the trial. But then requiring the defense to be produced and disclosed is close to revoking that charter right. You are making a person disclose the facts to the prosecution and to the prosecutrix before the case has started. It is like telling you have been, say, held up and the robber points a pistol at you and tells you, look here, I've got a bullet in this. One bullet, I don't have two. And you say, well, I want to see the bullet, and they remove the bullet from the chamber and shows it to you. Now, by the time he is taking the bullet out and showing it to you, the bullet has become useless, because by the time he puts the bullet back in the chamber, you can run away or start fighting without danger to yourself. This is what this bill is doing. And it's an appalling bill. It's an injudicious bill. It will make the accused individuals fail to provide a robust defense. And honestly, if the defense disclosure is such a big thing for the justice, then why only restrict it to the rape cases? Why restrict it only to the sexual assault cases? Why not make it for every case in the world? Make it an standing principle of prosecution that defense must show its card. Would you do it? You would not. You are picking and choosing. This cherry picking shows the nefarious intention of the government. Only in sexist cases you can be certain that law is heavily tilted in favor of finding men guilty of offense. The law is being amended and changed to show that once you are accused, you must be punished. This is nothing but turning the court of justice into a kangaroo court. And when it's a kangaroo court, then justice cannot be there. You know, the premise that a person is innocent till proved guilty, the premise that a person has a right to defend himself or herself, these two basic concepts are being vitiated and violated by Bill C-51. And I said earlier that the bill has already passed first two readings. It's in the committee stage. Now, I want to ask my legislative friends, the lawmakers, have they partaken or bidden goodbye to their sense of judgment? Are they so enamored of being politically correct and creating vote banks? They want to annihilate the very concept of jurisprudence. And why is it that there has been no public consultation? What has gone wrong with opposition? As a matter of fact, I don't blame opposition that much, because opposition is emasculated. Even when 71% of the Canadians oppose a decision, even then that decision is implemented. So you can well imagine, even if some people had opposed it, nothing would have happened. The draconian majority of non-thinking legislatures and the leaderships is playing havoc with the judicial system. And when it becomes a law, now the only hope would be that the Supreme Court of Canada, when such a case comes, declares the law to be ultra-virus, because it goes against the Charter. And not only against the Charter, it goes against the principle of jurisprudence. Our principles of jurisprudence have been vitiated by this law, which a number of criminal lawyers, as I told you about Anthony, the head of the Ontario Criminal Lawyers Association. They said such a law could never have been imagined, anti-humanity, anti-charter, anti-concept of jurisprudence. And the only purpose, as I said earlier, is to create a vote bank and to pose as champion of the women. Laudatory and not condemnatory objectives, but the means are bad. But in the process of getting a vote bank, you are destroying the very basis of honest, impartial judicial system. And that is unfortunate. That is really unfortunate. Think about it, friends. Thank you.